issues, but if you can come off mute, that's great. But if not, then hopefully you can watch the recording later and get some answers. All right, let's go ahead and get started with just some housekeeping slides while we're waiting on anybody else. So thank you all for obviously coming this morning to learn about intellectual property. Riveting subject, I know, but something that's it may not always be the most exciting thing to talk about, but it's pretty critical for your business to understand the different types of intellectual property and kind of the pros and cons or the benefits or what each one does. And it can be great, kind of confusing. And there's a lot of information out there that people will spout about IP, but it may not actually be quite that accurate. Or you always need to think about how it may apply to somebody else's business that way, but you need to think about how it applies to your business. So a couple housekeeping slides. So first, just want to talk a little bit about SCORE. So SCORE is a volunteer organization. So there's the SCORE National Organization, which is all across the US. And then we have different chapters. We are the Nashville chapter. So we offer things kind of local resources and support for kind of the small businesses in our area. We are separate from the SBA or Small Business Administration, but we work closely with them as far as kind of providing education and mentorship, where the SBA provides different services to small businesses, but we work hand in hand with them. If you want to put in the chat or the Q&A, or if you have a mentor now, so SCORE, one of the big things I said we provide is education and mentorship. So a SCORE mentor, again, is a volunteer. It's a free resource for your business. It's kind of think of them as your business coach. So if you don't have a mentor today, I always kind of encourage people to look at that as an option, because your mentor is there kind of that sounding board, and to kind of mentor has a great breadth of knowledge in a lot of different areas for businesses, small businesses, and can kind of help you, just kind of somebody to ask questions that has been in the industry or in business for a long time. They're not going to give you answers, but they can help you can ask questions, they can provide resources, they can kind of be that business coach for you and your small business. Again, it's a free resource. You can go on to the Nashville, in the bottom left-hand corner, you'll see the website for the Nashville chapter. So when you sign up, you want to make sure you go through the Nashville chapter to get assigned a local mentor. And again, they can meet with you and as frequently or infrequently as you want. And they're there to be a resource for you and however you want to use that. But I highly recommend, all the mentors are fantastic through SCORE. And so I always kind of recommend that as kind of a business coach that you can get as a free resource. The other thing SCORE provides is education. So there's workshops like this that the Nashville chapter puts on, local ones, online, and there's in-person events as well. And then there's the national organization. So there could be a webinar, something that the SCORE National puts on, and then there's ones that the local chapters put on. So we do, some happen every single month, are pretty regular, and then others are maybe every quarter. Sometimes some are just a couple times a year. There's some in-person events that we do that are kind of like all day, like a pitch competition that we do for women's small businesses. So there's various events. Now that you are signed up for this workshop, you'll get emails about these events, but you can always go out to the website and check out what's coming up. And Michelle does a great job of kind of putting 2 to 3 months out there online, so you kind of know what's coming up and can plan ahead. So who am I? I am Sandy DeWald. I'm the instructor today. I forgot to change my name and my Zoom title, but I am a SCORE volunteer. So again, just like Michelle, just like and all the ones that you meet in SCORE were all volunteers for the organization. What I am is a subject matter expert. So I would not be a mentor. I would not be your business coach, but the mentors bring me in for kind of deep dive on different topics that are more in my area of expertise. And then I do these workshops. So there's several different ones I do, including this intellectual property workshop. Areas of expertise is product development, product marketing. I've worked in manufacturing and product development and product marketing and just brand marketing for 20 plus years. So that's kind of my background. I also and in that role, you're like, well, how's that work with intellectual property? Well, I started my career out in the legal field, and then I've moved into product development, product marketing, I'm always the one that was dealing with trademarks and copyrights and patents and working with our in-house counsel or external counsel with to filing things, all kind of different legal aspects around that. I was always the person that's been involved. So that kind of brings me to what we're going to talk about today. First is the legal disclaimer. So this information is for educational purposes. I'm not a lawyer, so I'm not going to talk about specifics of this is how you file and this is the documentation you need and this is the, specifics of the actual like legal side of intellectual property. What I am going to talk about is more how is this seen from a business lens? As a business owner, how does intellectual property help your business? What things what kind of assets in your business should be protected, can't be protected, come from through a business lens, not from an actual lawyer, like I'm filling out the paperwork and here documents and here's how I file and I talk to the USPTO. So I'm coming at intellectual property from what is it, why is it important to your business, and what are the different types of intellectual property and which ones might apply to your business. So that's what we're going to cover today. We're going to say, what is intellectual property? People have heard you probably have all heard the different types of intellectual property. There's 4 types of intellectual property. Some apply to your business, some will not. So it's good to understand what they are and the differences between them and the rules and regulations around those different types of intellectual property, what they do cover, what they don't cover. And then maybe like have basic IP strategy, because you need to start thinking about strategically how can intellectual property be used in your business to make sure you're protected in your business, as well as that you've got everything in place to make sure if whether you need to, if somebody's infringing on your rights, how you can protect yourself, or kind of the things that you can use for intellectual property to help protect your business in other ways and give your business an advantage. Like I said, we're going to view the intellectual property today. We're going to talk about it through the business lens, not necessarily legal aspect of filing and all that, but how does it impact, help, or if you don't protect it, how can that hurt your business? We're going to mostly cover US IP policies and law. We're going to cover a little bit about how they might apply to international, just touch on that, but international is a whole nother can of worms in intellectual property in different areas. So we're going to kind of mostly focus on the US. Again, we're not going to cover very specifics about how to file and the documentation needed and the format of things. And I always say that you need to consult an intellectual property attorney, somebody that you can't go to somebody that does different types of law. Intellectual property is kind of a unique subset of law. So you need to make sure that if you do consult an attorney, that they have experience in intellectual property and specifically in the type of intellectual property that you're seeking to protect. Because there's very different ones, especially for like patents. You really need to make sure you're talking to a patent attorney. Just even a regular intellectual property attorney wouldn't be, may not be covering like patent law. So what is intellectual property? Again, at any time, it should be interactive. If you have a question, just pop it in the chat or in the Q&A box. Intellectual property. So think about intellectual property as it's a legal framework that protects the creations of the mind. So it gives those kind of creators and inventors exclusive rights, and that's important, exclusive rights over their mental creations. So the idea is that you have an idea for something. How can I protect that idea? And so it's not a physical building or a physical, well, it can be a physical object, but how are you protecting kind of that the creative aspect of your assets in your business? Think of IP as a way to kind of own ideas, just like you can own physical property, but you need to be able to kind of own that idea. Again, the whole point of intellectual property is to protect small businesses, to give them assets and advantages. Even if it's not something physical, it's something that's still important to their business. Your brand is still important to your business, even though that's an intangible asset. So how do you protect that? Just like you would protect your a physical building that your business. The key thing about intellectual property, again, it's intangible assets. So you can't, it gives you protection again for things that aren't necessarily like I can hold it in my hands. It's there are things that are kind of, but they are still important and key to your business. And companies spend a lot of money on protecting intellectual property because their brand, their reputation, all those intangible assets are worth something to the business. It does give you exclusive rights. So once you have intellectual property, you can control how that creation or that intangible asset is used, whether you want to license it, you share it, however you want to put that out into the market, you can control what that is and how it's done. Most intellectual property, except for trade secrets, is a limited time period. So the government is giving you exclusivity on this intellectual property with the IP rights, but it's not forever. So there sometimes are very long time limits, but there are time limits, except for trade secrets. We'll cover that later. But you don't get exclusivity forever and ever and ever. There is some time limit to it, kind of. Um, Again, an IP is territorial rights. So we're going to talk about regional rights, the US rights, there's international rights, different countries, there's different ways in international. So just because you have an IP right in the US does not mean that you have that same IP right across the entire world. So we have to think about IP. We're going to talk a little bit about how it works in the US and then touch briefly on kind of if you want to expand out, especially if you're like an e-commerce and you may sell to other parts of the world. So you may need to think about IP in other countries. Some of the common misconceptions about IP, because I hear these all the time, and I've seen these all the time in various companies I've worked at, so we will not name any names, but one of them is that intellectual property or IP protection is automatic. Like as soon as I come up with the idea, I'm automatically protected, and that it's complete, and that neither of those are 100% accurate. So some IP protection rights begin automatically, but often they're limited in their rights. So usually to get full intellectual property protection, you have to register that with the federal government. We're going to talk about the different types of IP and how that works, but just don't assume that because I've thought of this thing that I'm automatically protected and I'm protected everywhere and completely. The other one we think about as IP is too expensive for small businesses. And I would say some IP like patents are an expensive proposition, but the benefits of protecting that intellectual property can far outweigh the cost of filing for it. So we're going to talk a little bit about general costs for filing of different IP, but think about if somebody copies your business logo and starts infringing on your business, that can be very expensive cost to your business. You can go out of business if somebody else squats on your domain name, somebody else takes your logo and opens up a business right across the street, but they're copying all your stuff. I mean, those can be very detrimental to your business. So sometimes we think about the upfront costs, but we forget about what are the costs in the back end by not protecting your intellectual property. This was a really good one. People go, well, if I thought of it first, it's mine, right? No, it is not automatically yours. IP rights don't go to the first person who thinks of an idea or thinks of something. There are very specific things you have to do. But just saying it or telling somebody else about the idea does not give you any intellectual property rights. And it does, yeah, there's nothing, there are very specific things you have to do to fix that intellectual property right. And this is like my favorite. I can use anything I find online for my business. No, you can't. Nothing else. Let's just remember, you can't go out to Google, even though it shows images, and grab a screen and grab an image off the internet and use it. Like that's most online content is copyrighted, even if it doesn't explicitly state that it's copyrighted, and we'll talk about why that is. But and we'll talk about fair use, and we'll talk about when you can and can't use things. But let's just assume, right? Let's just go with the thing that things. You can't just use anything you want to online in your business. Ooh, that's a very dangerous one. And when people think all the time, it's like, well, if it's on the internet, I can use it. Like, no, you can't. So we're going to talk about the four types of intellectual property. So that's copyrights, which protect creative works, trademarks, which are brand identifiers, patents, which protect inventions and processes, and then trade secrets, which protect confidential business information. Most likely, the first two, copyrights and trademarks, are going to be the ones that are most applicable to small businesses. Some will, depending on the type of business, you may have patents, because if you're developing a new product, patents would be important. Trade secrets, depends on the type of business that you are in. May or may not be applicable. We'll cover those briefly, but I wanted to say that there's a kind of a sub-level of trade secrets, which is just kind of confidential business information. It may not rise to the level of a trade secret, but you probably have confidential information that you need to protect, even if it's not truly a trade secret. All right, so I'm checking the chats or anything. Okay, good. Just kind of going. All right, so let's dig into it. So like I said, we're going to go for a little while and probably hit the first two, depending on the time, and then maybe take a quick break and then cover the rest, but we'll see how we go. And you'll see these symbols on the right. You've probably seen these, whether you notice them or not. You'll see the little C with the copyright, the TM, the SM, the little R, the registered trademark. So those are kind of the symbols that you'll see a lot to identify these different types of intellectual property. So let's talk about copyright. So copyright is one of the intellectual property rights that is automatic, but it's automatic from the moment the creative work is fixed in a tangible form. So if I just tell somebody about the idea, or if I describe it and I write, I think of a poem and I just tell somebody about the poem, that is not copyright protected anymore. It has to be fixed in a tangible form. So what that means is that that's written work. So it's books, articles, website content, marketing materials, software code is actually copyrighted. So it's that idea, but it has to be fixed in a tangible form. It's visual works like photographs, graphics, artwork, architectural plans. Those again are all kind of visual medium, but they're fixed in a tangible form. Audio-visual works, so videos and music. And then there's compilations and derivative works. We'll talk a little bit about that later, but you can also copyright a derivative work that's inspired by and a copyrighted work if you take specific steps to make sure that your derivative work is transformative. So again, we'll talk about that in just a second. But so it may be a derivative work of something else, but you've done something to make it new and transformed so you can copyright that. I think of that one kind of the Andy Warhol when he did his famous like Campbell soup cans. So Campbell is a copy, Campbell would have intellectual property on that brand name, but because he transformed it into his artwork and created something new, he did not have to get Campbell's permission to be able to copyright that artwork that he made. What copyright does not protect: ideas or concepts. So again, it's not just the telling somebody idea or reciting the poem out loud or talking about it. It has to be actually in a tangible form, not just the expression of the idea. It does not cover facts, data, or information type, it's not that. Copyright is not a spreadsheet of tables with different data points in it. That's not copyrighted. Copyright is not for short phrases or titles. Those are later on, we'll see trademarks, and kind of those things would go into the trademark, not in copyright. And you can't copyright methods, systems, or processes. Those would be under patents and not in a copyright. So the one kind of curious thing about copyright is that books, the content of the book is copyrighted, but you can't actually copyright the title of a book. I don't really know why, but so that's sometimes you'll see books that have the same title, and that's for other reasons you shouldn't do that. But there's no really rule against having the title isn't copyrighted, but the content in the book itself is copyrighted. That's a curious little IP fact for today. All right, key thing with copyrights. So there's key rules and regulations. Like I said, even if to have the intellectual property, you still have to follow some rules to make sure that that copyrighted work still has all the parameters to make it copyrightable, if that's a word. So originality, it must be original to the author. Here's where the compilations and derivative works. So you can be inspired by or use a copyrighted work in a new creation if you are transforming that into something new. So Andy Warhol couldn't just take the Campbell soup can image and put it on a piece of canvas and use it, because that's literally taking that exact original copyrighted product or trademarked product and then putting it on canvas is not transformative. But he did other things to the work to transform it into a new artwork. Then he's okay. The thing, it must be fixed in a tangible medium. So we already talked about that. And really the bar, I'll say it's kind of low for creativity because creativity is so subjective. It's not like you have to create something, a work that's no one has ever seen before. I mean, that's not the part of it. It's just got to be creative out of your mind and your ideas. Doesn't have to be so earth-shattering that no one has ever seen it before. People have been painting forever. But your way you paint your idea on that canvas is copyrightable, even if it's a landscape painting and there's like millions of landscape paintings out there. The thing about for businesses for work for hire, so as an employer, you own the copyright, the company owns the copyright work that is created by, or copyright when work is created by employees within the scope of their employment. So if you have somebody that works for you and they create a training document, the company owns the copyright to that document. The actual person, the employee, does not, because they made it as part of their work for hire, as part of their work for the company. Same thing with independent contractors. If you have a graphic designer and you have him do some, uh, you know, a logo, or he does some artwork for a website or something, in that contract with that graphic designer, all the graphic designer should assign all of his rights to the company. So, and they do it all the time. That's very common. No graphic designer knows if you're hiring them, they're getting paid to produce the work. They understand that the work is owned by the company, not by them. And that's pretty standard in every contract, but just make sure it's in there if you have any contract that the individual person is assigning their rights to the company. We'll talk about fair use exceptions. So there are fair use, and this is where people get really kind of all turned around in copyright because they think a lot of things are fair use when they're not. Fair use exception is very limited. You can use it for criticism, education, parody, and like news reporting. So those are kind of the only times where you can take somebody's original work and as is and use it, because you're like criticism, like you're commenting or critiquing, like in a book review, that original work, where you're allowed to quote that original work to be able to critique it, that kind of thing. So we'll talk a little bit more about fair use, but it's not just because it's out there, I can take a short snippet and use it for any reason. Copyright is a first to invent system. So we're going to talk about first to invent, first to use, and first to file. So they're kind of the three priority drivers that determine when an intellectual property protection starts. Copyright is first to invent. So the first time that creator fixes that work on something tangible form, that's when the copyright starts. It doesn't matter when they actually register it. It doesn't matter anything else. It's like if they can prove the date and time when they fixed it to in a tangible form, that's when the copyright starts for that creator. We are going to talk a little bit about automatic copyright rights, and registering your copyright and the differences and the benefits of registering your copyright, which is the next slide. So yes, your copyright you have automatic protection from the moment you fix that idea in a tangible form. I don't have to register it with the government. I don't have to do anything. I don't even have to I don't even have to mark it with the little C symbol. I own that copyright, whether it's once it's fixed into a tangible form, whether I mark it with the C or not, and whether I register it with the US Copyright Office or not. So that's really nice about copyright. However, registering that copyright, that material with the federal government, the US Copyright Office, will give you significant legal advantages. So if you just have a copyright and you don't register with the federal government, um, you do have protections, but your protections are limited. When you register that copyright, the presumption is that you are the owner and you are more valid standing in court. So again, somebody is trying to infringe on you. You're like going, look, I proved, I registered it, I gave notice, people knew that it was registered, that I have a stronger state position in court because I went through the steps to notify and protect and get the full protection of that copyright law. With copyright law, by registering it, you get statutory damages where if you didn't, you might only be able to get compensatory. Compensatory is when you have to show actual damage, which is very hard sometimes in intellectual property. How do I show damage to my reputation? How do I show damage to my brand? Without filing, you would just get physical damages that you could prove, like an actual harm, like maybe you could prove lost sales or something, or that somebody dropped me because they went to the person over here stealing my copyright. I don't know. Statutory damages let you get all those kind of intangibles of damages to your reputation and brand and those things that be hard to prove. There's no physical like receipt to show that, but you can get those damages because you've registered it. You can recover attorney's fees if you register. You're not going to be able to recover attorney's fees if you don't. So if you have to bring an action by having registered the copyright, you can get your attorney's fees covered by the other party. And then it gets to a stronger enforcement position. By doing that, you're giving notice and that you're stating that this is so important to me that I want to register it, and I want the full protection that the law can give me because this is very essential to my business. So copyright, this is where you hear like many, many, many years for your copyright, which is nice. So individual creators, it's the life of the author plus 70 years. So that's why there's a lot of books written back years and years ago, and the author has passed. So it's through the life of the author. And then once the author dies, they still have 70 more years. So that's why you'll see some books every year go out of copyright because it was the author's life, however long they lived, and then that 70-year time frame has finally passed, and now it's in public domain. If it's a corporate copyright or like a work for hire situation, it's 95 years from first publication or 120 years from creation. So again, whichever is shorter. So whether you first publish it or maybe you create it and then I don't know why, but you don't publish anything about it for 10 years. But you still, again, copyright starts when you first fix it in tangible form. So if I wrote a book or corporate, I wrote a training manual, but we didn't use it for 10 years. I don't know. Then I published it. Well, my copyright could be either from when I published it or when I created it, whichever is shorter between those two. And then any anonymous works or pseudonyms would be that 95 years from publication or 120 years from creation, because you don't know, was it an individual or a corporate? So they're kind of giving the benefit of the doubt and using kind of the corporate length for anonymous works. When to register. So please register. You don't register after somebody infringes on your copyright. That is not the time to do it. So if you're going to file that copyright, you need to do it before any infringement occurs, because if you do it afterwards and try to like, oh no, I registered it, so I can get extra protection. Like, no, because you've already been aware of the infringement, and so it's not going to give you extra protection. Copyright's really not that expensive. These are it can, depending on what it is and filing method, it's pretty reasonable, less than $200 to file a copyright. So it's really inexpensive for the protection that you get. Of course, these are costs right now. The I just know that the USPTO just raised their rates for filing patents. So I don't know if other offices in the government, because of what's going on, will also start raising their fees. But in general, it's not a hugely expensive investment to file for a copyright. That little,
Sandy?
yeah.
No, I'm sorry.
Oh yeah.
Christina wants to know, so if you write a story and it's on your computer, is it copyrighted?
Yes, it's you get automatic copyrights because it's fixed into a into a tangible form. It's still digital, still tangible. Um, and the nice thing about that is you would have a date. Like usually there's a file name and like a date in there, so you would know when that form was fixed, I guess. So you'd have a date of when the copyright would start. Good question. You can use that little copyright symbol. Whether you register it with the federal government or not, you can always put that little copyright symbol. Again, you don't have to even use a copyright symbol. You can still have automatic rights. But once you register it, you really do want to use this. I'd say use a little CC symbol on everything because it gives notice that you are serious about protecting this, whether you've registered it or not. Just kind of a best practice. As far as international protection, which is kind of nice for copyrights, because the US, as of right now, is part of the Berne Convention. And there's another, I can't remember, there's another one like TRIPS or something. There's another like agreement between different countries that automatically protects our copyrights filed in the US in about 170 other countries. Not every country, but again, we have, because we're part of that, as long as we stay part of that Berne Convention, then again, it's still enforcement and filing and stuff like that in other countries, but at least you kind of have that automatic kind of protection for your copyright in other countries. Copyright and fair use. So people will often think, well, it's fair use, so I can just use this snippet from this book or from this song. Especially big thing is podcasts will want to use like music, and they'll think, well, it's just a 30-second snippet or it's a 10-second snippet I'm using for my intro music, like, and I can just go grab the latest, Taylor Swift song and use it. Nope, you can't. So um, that's not fair use. So fair use does permit the unlicensed use of the copyrighted material for specific purposes. That's like criticism, commentary, news reporting, teaching, scholarship, research. So it's education, critical criticism, or for news reporting, because they can't, I mean, it'd be hard for them to go back every single time to reference something copyrighted, to get permission from the original copywriter, copyright holder. So those are very limited exceptions. Um, you can, again, fair use does allow you to use that copyrighted work without requiring permission from the copyright holder. But it's not a blanket exception. Even in those areas, you want to always have kind of careful consideration of what you're doing. There's some key factors that you have to kind of consider under fair use. So examples of fair use is like maybe you quote a short passage from the book in a book review. So again, you're commenting or doing a kind of a book review criticism of the book, but you need to pull passages from the book to illustrate your points in the commentary. That's okay. Um, I could use if I went out and grabbed McDonald's logo or I quoted from some speech that somebody, something that somebody gave on or something like that. I could then use that material here in this presentation because this is an educational presentation for educational purposes, not so I could use that kind of a clip from YouTube on in here because it would be under fair use. Parodies is the other one. That's how if anyone remembers Weird Al Yankovic, okay, I'm a Weird Al. And his parodies of like Michael Jackson's Beat It. I remember that one where he created, so he used the same music, but he had his own lyrics. So he was able to do that because it was a parody. Or comedy people, in comic stand-ups, they can um, use copyrighted material if they're parroting that original material, because people know you have to have the reference to the original to understand the parody. So those are kind of fair use exceptions. The key factors for fair use is the purpose of the use. If you're going to use it for commercial reasons, most likely not going to use it. That's why the podcasters, because it's a commercial use, then they're not, most likely that's why they can't use Taylor Swift's song. It's for educational nonprofit. Okay, then that's a different. You're not profiting off the use of that copyrighted material. If you transform it in some way or use it in a different for a different purpose or different than the original material, so there's not a harm or damage to that original market. Um, it depends if it's factual versus creative. So if I'm like quoting a book for a stat and I quote that copyrighted material from a website because I need that stat, that's a factual use and they're probably going to be okay versus I'm taking somebody's poem and using that in my work, in my what I want to use it for. The amount and substantiality of the portion used. So if it's a small little section, like I'm just quoting like this phrase or a sentence or two, and it's not the heart of the work, like it's like not the essential point of the original work. You're not kind of taking that, but you're just kind of taking small snippets to kind of, again, showcase something to in your own, like a reference point, more likely is okay. And they're also going to look at the effect of the use on the potential market. So does your use of the copyrighted material harm the market for the original copyrighted work? So if um, so like I think of like books and they do those summaries. If if somebody reads the summary and they don't go back and read the whole book, then I've harmed the person's original copyright because I'm taking somebody would have bought and paid for their original work, but they didn't because they read my summary. So the hard part of copyright is not clear cut. You have to kind of analyze
Sandy?
all, yeah.
Oh, I'm sorry.
No, no.
Um, Christine came back and said, she has her story on the computer that's copyrighted, but she wants to know, is it still copyrighted if she's still working on it?
Yes, so the copyright, so if you have versions or additions or changes, your copyright would then just move to whenever that new date is. So you'll see this on websites a lot too. They'll copyright 2025, and then I update that website next year, the copyright on that website will change to 2026. So you want to be able to show your original fixed date and then the dates of any changes or edits to that. Um, because that will move the date of that copyright. That'll continue to move the date of the copyright. So just think about them in versions of your original work would still be fixed to the original date. Your edited version one would be fixed to a new copyright date that's further in time. Your version two, further in time. Version three, further in time. So you're still protected, but you need to make sure to track those dates kind of when you're making changes so you can move the goalposts on because you want the copyright to move because the late or the more current in time the copyright is, the more time on the back end that you have protection on that copyright, if that makes sense. Michelle will tell me if it doesn't. For fair use, just make sure that these factors are not weighted equally. Um, if there's any question, just seek permission from the copyright holder. A lot of times, if you're quoting it, they're they'll be okay with it, especially if it's you're not trying to make a profit or off their work. And then the U.S. Copyright Office has a fair use index where they give you more resources about how to um, determine fair use. It's kind of a fuzzy area because there's a lot of factors like, well, how much is substantive and how much is what's transformative and were you really, what was the purpose you're using it for? So there's a lot of things that kind of factor into fair use. It's not black and white like a lot of things in the laws. As much as we think it's black and white, it's not really, kind of depends on the situation. The key thing is that best practice is to attribution to the original work. So if you do pull a quote or you do pull information, link back to that original source where you got that, quote the author that created it or quote the person that inspired you with the artwork or whatever, so if you can kind of give that attribution back to the original source is always the best practice. Even if it's fair use, it's still good to know, hey, I I was inspired by this or I used this to now create this. I'm going to talk a little about copyright and AI. I saw so copyright and trademark are probably the two biggest areas because they do have a lot of implications in small businesses, and AI is another one. You're going to hear a lot, all the lawsuits around AI that are going through the courts have to do with copyright law. So there's two, we'll separate that out. There's people suing the large language models like the Chat GPTs or the um, Google Gemini or the Microsoft Copilot, whatever it is. There are people saying, well, you trained on my copyrighted work for these models, so you've infringed on my copyrights. That's not what I'm talking about here. That's a whole separate area of legal. That's between the copyright holder and those companies and the large language models. They'll work that out, whatever that is. What I'm talking about is you as a when you go into these models and you get information back out for your specific business. So let's focus on that. So that's when you go in and get like text for marketing copy, blogs, product descriptions. There's the ones that do image creation, like graphics and logos. Like you can get your logo now done in by AI and images, things like that. AI generated videos, voiceovers. Now you have like work and create podcasts for you, and it can do, there's a lot of audio voiceovers that you can have it create. And then also you can have AI generate code for you for like website development or app creation. Those are kind of things I'm talking about with AI generated content that might be applicable to a small business. So right now, and I have a caveat right now, because these are things are still even are in flux within the US Copyright Office. So their current position is that works produced by machines without human authorship cannot be copyrighted. The key thing on copyright is that it has to be human creativity and authorship is needed for copyright protection. Sounds very black and white, doesn't it? Okay. The gray area is when it's AI assisted, but maybe not fully AI generated, may or may not qualify for copyright. That's the gray area that is still being worked out. I'm going to give you some kind of guidelines and things to think about, but just know that that's like with anything, we'll have to kind of keep watching the cases as they go through and keep watching what the US Copyright Office information that it puts out. So general guidelines for your business and with AI generated content. If it's pure AI content, like it's pure output, like you take that raw chat GPT response and you do nothing to it and you put it out there on a website, you're probably not going to get any copyright protection because you didn't do anything. I mean, putting a prompt in is not enough human authorship. Um, you're just taking the raw AI response. And again, competitors copy it. There's nothing there's probably they're gonna if it's someone challenged, if you wanted to challenge on it, you wouldn't probably have any standing because you're like you didn't do anything there was no human that actually informed the work. Typing in a prompt is not enough human interaction. So say if you typed a prompt into the AI model and then you got a response back, but then you really edited it. You rewrote, say, 50% of it, or you did some significant editing. You kind of, or you used it as here's an outline, but then I kind of went through and I fleshed out the outline, that kind of thing. Copyright's probably okay, probably possible in that situation. Again, not 100%. It just depends on your human contribution. If you went through and just did rearranging some paragraphs and maybe adding a closing or an intro or a closing paragraph, that's probably not significant contribution enough. But if you went through and kind of rewrote it and added your own experiences and your stories and, you know, then again, it's more likely to be able to be copyrighted. If you use AI as a tool, like to help you research, like I said, again, that first draft, again, that rough outline, those things, and then it's just doing kind of the research for you. It's finding the information, but then you are actually kind of writing the thing, then you're probably okay with copyright because it's assisting you like any kind of research tool is. Like if I go to Google and I research something, or if I use another tool, the database tools that research things. So it's similar to that, then you're again, but the output is still yours, then you're more like, then copyright protection is probably um, viable. Here's the gray, probably the grayest part. If you have use AI and you maybe give it prompts and some direction and maybe do a little bit of editing, it, it's unclear. It's where how much human interaction is the Copyright Office going to require, you know, to make it actually a copyrighted work and not machine. And that's where they're still trying to figure that out. Like, where's that line? And it may not be something we decide for a while. So just kind of know that if you are using the AI for kind of the bulk of it and you do a little bit of editing and people are trying to get away with, well, I gave it the prompt, so that means I gave it direction and that's my contribution and it only created the work because I put in the prompt. Like that's not going to fly. That's not enough human creativity, I don't think, in my personal opinion. Again, this is not legal disclaimer from the beginning on this one, but that's kind of like where I'm seeing, at least what I'm seeing in discussions about this. So just kind of think about that going forward with AI. Okay, we're going to move on to trademarks. Is there anything else on a copyrights? All right.
No questions on
Let's,
chat.
I know, let's get through trademarks. It's kind of it's another big section. I know we're getting close to the hour, but I'd like to get through some of this and then maybe take a little break and come back on the other ones. Because trademarks is big. So the other one besides copyright is going to be trademarks. That's where you see the R is the registered trademark, a TM is trademark, and SM is service mark. For our discussions, service and SM and a TM, service mark, trademark, or trademarks are all the same, whether it's a service mark or a trademark. Um, they are all kind of protected equally under the trademark law. So trademark rights are automatic through the use of a mark in commerce. So just because I created it and it sits on my computer, that does not give you any trademark rights. It's once I start using that trademark in commerce. So that means I start using it on my products that are going out there. It's on my packaging. It's on my, it's my business name. It's my logo. And I start using it in commerce. That's when the trademark rights start. So that's like your business names can be trademarked. We'll talk a little bit about business names, but you can trademark your business name or service mark, actually service mark the business name, but you can trademark your products, logos, slogans, so just do it. You can actually trademark distinctive colors, sounds, shape, and distinctive packaging, which is called trade dress. It's a form of trademark. So um, when you think of like DeWalt and that yellow that DeWalt uses on all their tools, that yellow is actually trademarked because it's a very specific yellow. It's a custom color they created, and they use it for all their products. So it's a brand identifier. So they actually have trademarked that yellow. Coca-Cola bottle, that shape of that bottle is trademarked because that's a very distinctive shape. It's very integral to the Coca-Cola brand. So those are examples of trade dress. Again, it still comes under trademark, but it's just a different form. Trademarks are used to identify goods or physical products, and then service marks are just used to identify services. Whether it's a service mark or trademark, they're handled the same. It's just knowing I'm really getting a service mark if I'm a service business and I'm trademarking it if I'm putting it on a product name. Key rules about trademarks. It's got to be distinctive. So it must identify and distinguish your goods and services. So it can't just be another logo slightly tweaked and then I can trademark it. Like, no, if we always talk about if there's confusion in the mind of the customer, then it can't be trademarked because if that's the whole point, you can't be so close to another brand's trademark that you're confusing customers about, wait a minute, is this the right one or is this the right one? Like what's going on here? Or why are they doing this and this? Um, you have to actually use it in commerce. So again, you can't just create the logo and have it sitting on your computer. You actually have to use it in business. And you can't just think of the idea and like, oh, I'm going to use it on a product someday. Until you use it on an actual product in the market, it's not trademarked yet. Can't be descriptive. So fast pizza is too generic, but Domino's pizza is distinctive. Um, descriptive is like a lot of people want to use very descriptive terms to name things and don't. I mean, we want to be descriptive in what our product does a lot of times, but I see a big thing of like they'll want to use, something like speedy service. And like, well, that's so descriptive, that's so generic that how do I know what that is? That's just too generic. So you have, but like something like Apple, and you're like, well, Apple's a pretty generic term, so how can they trademark that? Well, Apple applied to computers is different than Apple when you think of it as a food group. So sometimes the class, and we'll talk about class of goods and services. So when you file for a trademark, you pick a specific class or of goods and services that you're trademarking that in. You don't get a blanket trademark across everything. You have to pick which goods or services you want that trademark to apply to. So when Apple did it, they applied it to electronics and computers, and we're able to get that even though it's a generic name because the goods and services applied to, nobody calls a computer Apple. Like that's just crazy, right? So that's how they were able to get that. It can't be confusingly similar to existing trademarks. So you can't just take the Apple logo and change it to different colors and use it and file for a trademark. Um, when there's trademarks, again, they're automatic when you start using them in commerce, but again, same thing with copyrights. You can also file or register that trademark versus just using it. So there's two, again, different levels of protection by just using it in commerce, which is called like common law trademark versus registered trademark. So that TM symbol is used before you've registered it, you can still identify as a trademarked product by using that TM. Actually, you must use the TM to signify that you're trademarking that logo or slogan or product. And then after you file, then you would change that to the little R when the registration is approved. Again, you file for a class of goods or services. So you have to specify what marks or categories your mark is covering. So we would search all the time for within our type product category. Somebody could have a similar trademark in a wholly different category, and that's fine. I can still have that same trademark in my product or category. As long as they weren't in my category, I could still use that product name, even if it's something similar is in another type of product. And you have to continuously use it. If you abandon it or stop using the mark, then you're losing your rights because you have a period of time with the trademark, but it's not forever. It's not just I create it once. I sell product for a year under that brand name or that product name, and then I never sell it again. I keep that rights to that name. I lose that. I essentially abandon the mark when I don't use it. Trademarks is the first to use. So the rights go to whoever first uses it in commerce. So sometimes we've had people where um, part of what we would search too is if somebody else is already using the mark, even if they haven't filed for the trademark, registered it, I still have to search the market to see if somebody is using that product name or that slogan, even if in commerce, because if they've started using it, they have the first to use right. I would be infringing by using that same. So that's why registering it is best, but some people don't always do that. So you always have to search if it's being used in commerce, even if it's not registered with the trademark office. Length of protection. So it's potentially indefinite for trademarks as long as you maintain the trademark and use it in commerce. Again, that when you stop using it, you lose the rights to the trademark. So, but I could have that's why companies have logos and brands and products that I mean they can use that same name for ever if they want to, as long as they maintain it, pay the filing fees to maintain that trademark and continually keep using it in commerce. The initial term when you register the trademark is 10 years from registration, and then every 10 years you renew it. That's when you actually register it. If you do the common law and don't register it, you just have to continually keep using that mark. And then you have to file a declaration of use between year 5 and 6. So those are just some things to maintain that registration. The government wants to know that, hey, you're still using it, right? You haven't abandoned it. And I don't want to wait 10 years. So I'm like, they do like a check-in halfway through, like, still using it? Prove to me that you're still using it, and then we'll continue on for the next 10 years or the remainder of the 10 years. So trademarks are really good for if you need to establish a strong brand identity. We'll talk about trademarks if you want to, if you're selling across the US, if you're selling to, more expanding your business, or if something that you think is really kind of critical brand identifier to your business, you should really register your trademark. Cost is, I mean, again, with everything, there's always a cost to a business, but it's not outlandish. It's depending on the class of goods that you're registering for, 250, 750. Again, these cost fees could change depending on the government and in what they're doing, but in general, say it's under $1,000. Okay, and that's attorney's fees, and then there's some maintenance fees, attorney to file it, and then there's like that every 10 years you pay a fee to maintain the mark when you register it. Again, you must always demonstrate and prove. So when I would send in for the renewals or anytime I'd file a new one or that declaration of use, I had to show a physical picture. I had to send in a physical picture of that mark being used in commerce. So you actually have to prove that you're using it. You can't just say, yeah, I'm still using it, and they're going to trust you. You submit a physical use, what's on the packaging, it's on the product, it's your marketing literature, whatever it is that still uses that mark. You've got to show it being in use. So common law versus federal. So again, we just talked about trademarks being automatic for when you first start using them, not when you first think of it or create the logo or come up with the slogan. It's when you start using it in commerce. Common law, again, that's what we kind of call common law. If I don't register it with the federal government, I still have protections under trademark when I start using that mark. Again, federal registration, I file an application with the US Patent and Trademark Office. I have to meet those legal requirements. And again, it creates a federal record of your trademark. So that's the kind of difference between the two. So the key thing is that if you don't if you don't register the trademark, your rights are going to be kind of limited in scope for like the common law trademark. So they're going to be limited to the geographic area where you actually physically use the mark. So it's going to be if you're a local business and you're only going to stay local, that may be fine because it's only going to be covering you in that kind of small geographic local area where you're using the mark. If I have a business in Nashville, eh, I, I'm not protected because it's in something in California, because if I sell products there, I'm going to protect it here in just my little local area. It's based on the first use in commerce in that area. So you always want to document with anything with intellectual property, document when you start using it. Put it in a spreadsheet, make a note. I don't know what it is, but create a date because you will always be asked, when is the date you first started? And going back 5 years later to remember when you first used something will make you crazy. Just mark that date. Um, it's harder to prove, it relies on documentation actually is if you don't keep that documentation of when you started using it, then you could say, well, I think it was like 2025-ish. That's going to be really hard if somebody come to protect. If somebody's going, well, I used mine in 2024. Well, you can't prove when you started, like, or I used mine in 2026, but you can't prove you started it in 2025. So it's just harder to prove. Again, it will last as long as you continue using that mark. So just like you still get that same protection whether you file for the registered trademark or not. However, filing with the USPTO gives you additional benefits. So that gives you nationwide protection. So if I'm a business in Tennessee, but I sell products in California, filing for the federal trademark registration protects me in California because I've given notice at the federal level that I'm protecting this trademark across the US. Again, also filing with the federal gives you a specific date, like you actually date of filing, or you can also put in your date of first use, but it fixes that date in time and makes it very clear when you're stating your trademark rights started. It gives evidence. The biggest thing for federal trademark or any kind of federally registering a trademark or copyright is it gives notice to other companies. It gives notice. It's very clear. I'm protecting this. I think this is important to my business. I'm clearly stating across the board, hey, this is mine. Don't infringe on this. Where, they could say, well, if you don't file it, it's harder to find. Oh, well, I didn't know I was infringing. They're going to get more kind of benefit of the doubt because you didn't kind of state that they could say, well, no, look, it's in the Federal Register. You could have found them. Um, Again, it's 10-year renewable terms. It's still indefinite, but you just have to do that renewal process every 10 years with the federal government. So just a couple things. Consider common law if you're like truly a local business, there's no expansions, you're very geographic, you're only going to be kind of right here. Or maybe it's early on, you're still testing that business concept. You're not sure if that's the slogan you're going to stay with, or, maybe you're not sure that that's the right final product name. Because I've had product names that get changed and you're like, well, maybe I'm not sure if this, or you're testing it with customers, like doing pilot tests or beta tests. Maybe you don't file at that point till you kind of finalize everything. However, I would kind of strongly recommend filing a federal registration if you ever plan to sell online, you plan to sell outside of a different geographic area, maybe expand your business, or just to protect from competitors using that similar name. Because again, that federal registration puts them on notice. They could always claim like, well, I didn't know you were selling, you were this business in Nashville when I'm in Memphis. Just didn't know you were over there. And but where it's just kind of deters them from, puts them on notice about your trademark, and that you're seriously saying it's an asset to your business. I think this is the last one, and maybe we'll take a break after this. Um, Okay, sorry. Special cases that people often assume are protected by trademark law or can be protected by trademark law, but may not really be protected by trademark law. So, um, business name. So technically, when you file for your business and you do all the paperwork to set up a business and incorporate it, or whether it's a C corp or whatever it is, um, registering a business name with the state or local entity is not registering that business name with the federal government as a trademark or a service mark. So registering that business name gives you the legal right to operate that business in your state or locality, prevents other businesses from registering that same name in your jurisdiction, in your area. But it does not mean that that automatically gets registered or protected under trademark law. You still have the common law rights to that name, but you don't have, it's not registered with the USPTO. You still have to do that as a separate action if you want to protect that business name as a trademark, um, and registered as a trademark. You still have to do that with filing with the USPTO. Domain names, they're not registered or protected like a trademark. So you don't register a domain name with the USPTO. That's a separate entity called ICANN. Um, don't ask me what ICANN stands for. It's kind of weird, but that's where the domain name is registered. So domain names aren't protected like a trademark. However, they can be involved in trademark infringement actions. If you register a domain name with ICANN, that could possibly infringe or be on somebody's trademark. So if I registered Coca-Cola 123, I'm probably going to get an infringement action as part of a trademark infringement on from Coca-Cola because that domain name is infringing on their trademark. So domain names aren't trademarked, but I can still be part of infringement by not by using domain names that could be considered too close to a trademark. So just kind of think through that. And then the other one was social media handles. They're not somebody will because somebody whatever yours is, maybe yours is at cat mom lovers. I don't know, I have cats, so cat moms. Um, but somebody could be cat mom 3. I can't stop them from being cat mom 3, and I'm cat mom. Those are not registered or protected under trademark law. What I would say is the best practice for social media handles is to register, meaning sign up with that name or registered under those different platforms, even if you're not going to be using that platform. So I always say, hey, go get that Facebook, even if you don't want to use Facebook, get that handle on Facebook, even if you don't post anything there, but you claimed that username, or on Instagram or wherever, just so you can kind of hold, you're kind of place holding that name so somebody can't come in and use Cat Mom. And I'm Cat Mom on Instagram, but I have to be uh something else on Facebook because I didn't go, get that same username. So for your brand, you want that consistency across all platforms, whether you use the platform or not. You still need to kind of go claim it, but that's not anything to do with trademark law. All right, next is patents. So you want to take a quick break or we can keep going through. It's up to you guys. Or there's questions.
Christina came back for one
Oh,
more
okay.
and she said she's not in business anymore. She works for hire. What about copyright?
Yeah, so anything you should have, okay, first of all, if you're a independent contractor, you should always have a contract with the company that you're working with that's hiring you. Even if it's a one-page quick thing that just lays out um the scope of work. Usually you get you like a scope of work, or you could put some kind of thing on there. Um there technically, if the company doesn't state it, more than likely it's a work for hire. You're being paid for the work for that company. You're whether it's explicitly stated or not, your rights will go to the company. The company is paying you to create that asset. They're going to own the rights to that. It The best practice is to clearly state that in a contract that you are assigning rights, that the company owns those rights, whatever it is. But if you don't, the company's still going to own those rights. It'll be harder to it's like with anything with in court, it's always easier to prove if it's clearly stated in a contract. It's just going to be they'll have to a little extra hurdle, but courts are always going to side with the company saying, "I paid you for that work." The precedent for work for hire is that the company owns those copyrights.
Okay, very good. Can we take a short break?
Yeah.
I need one.
Okay. It is 10:09, maybe like 5 minutes, like maybe quarter after. Is that right?
Sounds good.
Okay.
See you
But I'm just
then.
going to stay here if anybody has any other questions.
Good.
I'm just going to look in the chat or look. All good info. Yeah, once you start looking at trademarks, you'll see them everywhere, or copyrights.
Sandy, you see a couple of questions or comments in the chat, do you not, from Christina and
Yeah.
Melody?
Yeah,
Good.
I just came off mute to tell you that I saw those and I'll answer those when we kind of come back together, just to make sure
Sure,
everybody's
no
back.
problem.
But no, but thank you for letting me know that.
That's what
Actually
I'm here
was,
for.
I know, thank you. Uh, I'm actually slightly more prepared, so I got a second screen and I've this time I actually remember to kind of set it up and have the chat and the Q&A box over on that screen because when I'm presenting, all those go away and I can't see them. So
Mhm.
I like I'm like, oh, I remember to actually hook up my second screen. But it's still hard to do. That's why I'm kind of looking down over here like oh, to see, but it's still hard to do when you're presenting because I'm in the flow, you know. I
Of
want to
course it
roll.
is. Sure.
Get about one more minute and everybody get back.
I don't know if it's still valid, but Melody's question, my brother's a screenwriter in Los Angeles, and that's what he's done for years. And I don't
Yeah.
know with
Yeah.
computers now if he needs to, but
Yeah.
and it's not registered. He just sends it in an envelope.
Yeah. Yeah. That I'll talk about that because that's an oldie but a goodie, you know, from the back in the
Not
day.
necessary anymore, huh?
Not with digital. It was back in the day. It was that when people were typing things out or handwriting things out, and that was kind of a good best practice then. There's some benefits to technology.
There's a lot of benefits.
Like we said in the beginning, when it works, it is great. Yeah,
I'm
and then
sorry.
I said when it works, it's great. Uh,
Yep.
it's the 9 times out of 10 that it works, but the one time you're just like, oh man, what's going on with that? I'm
And
actually gonna.
especially when you're technology challenged like I am.
Well, and like you're like other times you're like, man, I seriously, I promise you, I practiced this. I tested this. I made it. It was working beautifully 5 minutes ago. And you know that's so true. Like you know they did it. You know they thought about it. They were trying to be prepared, and then, oh, like what?
We've had that a number of times with our webinars.
Mm, yeah. All right, we're gonna kind of see if everybody's back. I don't know if you can, if it's possible to
Can't
put
tell.
in the chat maybe or something like okay or back or good or something. Or I don't know, can you do a little thumbs up symbol?
Sure. Oh, Christina's here.
Oh, well, good, because I'm going to answer a couple questions came in. Let me scroll back up to those. So Christine, your clarification that you created works audio for a company that is no longer in business. May I use the copy that I created for a new creative work, a book? Okay, this is not legal advice, so let's just preface with that. Technically, so you created the work for that company, they own the copyrights. The issue and what would have been ideal is in the contract that you said if the company no longer is in business, those copyright rights revert back to you as the owner. That would have been the ideal. So in future contracts, maybe put that in there that if for some reason the company stops using it or goes out of business, that those copyright rights go back to you. Technically, they don't. They stay with that company. Now, the question is, if they're no longer in business, you can't ask them for the rights to use. Um, so you'd really have to consult a lawyer to see if he can file something, because you'd have to file to say, I want those copyrights back. That would have to be some kind of legal, whether it's if they've stopped using business, there's probably still somebody that's um like the owner of the business. If you knew the owner of the business, you could maybe approach them directly if they still have an email, say, hey, these were part of a work for hire. I'd like to get these copyrights back. And it may just be something in writing, depending if they were federally registered copyright or if it was just a common law. If it's just kind of a common law, and they never registered the rights, again, consult an attorney, but you might be able just to approach them and get in writing from them that they're assigning those rights back to you as the owner of the business no longer operating. So that might be one way. If they federally registered those rights, then they're going to have to file something because you need the federal register to change those rights from the company, even if it's defunct, from the company, because the copyrights again last for 95 years. So that company still owns those rights for 90, even if they're no longer in business, they technically still own those rights. So you need to have a lawyer file something with the Copyright Office, yeah, after have, contact the owner, say, hey, that they're assigning the owner of the business would still have to assign those rights back to you. And we'd want to change that in the federal register. So that's kind of my advice. But a lawyer could tell you kind of specifics, and it may not be that big. If you still know who the person that owned the business, it may just be easy to reach out to them. And you can find out if they were registered, federally registered or not. That's again, you can check the Copyright Office to see if they were registered, and then kind of go from there. That would be my advice. The other one from Melody, hopefully, hope that helped. The other one from Melody is, someone told me years ago that a quick way to ensure copyright of written work is to mail a copy to yourself, registered letter, and then never open it. Wait, wait, I lost my screen. Never open it, and unless you need to defend your copyrights. So Michelle and I were just laughing. So back in the day, when before digital, when people were typing things on a typewriter, or handwriting things, yes, that was kind of the standard practice, is to, if you did not file a federal registration or for that copyright, if you're just relying on common law, that was a way people did that often to mail themselves, because that fixed that, it gave them a date for that tangible asset, because otherwise it was just typed pages on a on paper, and there was no, there's no proof of what date that was. So that was the idea, is that the date in the mail, the stamp, the mark from the US Post Office would say it was mailed on this date, and that would fix the date. Current with, if it's digital, there's no need to do that, because your digital documents all have dates attached to them. So that's easier to prove. Your common law, or your automatic copyright start. So, all right, is there anything else, Michelle? All right, cool. Oh, good. Glad that answered your question, Christina. Okay, let's go into patents. Now, this may not apply to anybody, but it's still good just to understand about patents. But it won't be, patents and trade secrets won't be as nearly as in depth as copyright and trademark, because they don't, patents only apply to a certain subsection of businesses. Oh, there we go. So patent protection is not automatic. So it's different than trademark and copyrights. There is no automatic protection for a patent. The rights go to whoever files first. So we talked about first to use for trademark. So it's first to use in commerce. First to invent for copyright. Whoever creates it, invents it, gets the is the copyright holder. Patents, it's the first to file. So whoever files first gets patent protection. Patents protect inventions, machines, processes, or improvements to existing inventions. Patents can also be applied to chemical composition. So that's like drug companies and drug discovery will patent the chemical composition of a drug. You can also, manufacturing methods, software algorithms can be patented. Software, but you're not patenting the algorithm, you're patenting the process method, what it does. You're not necessarily patenting the code. Code would still be copyrighted. So it's software is just a kind of a weird beast anyway, because you can patent software. It's really difficult to patent software. You mostly get a copyright for the code. And then patents can also be ornamental designs. So we're going to talk about different types of patents, but the outside look, appearance, and design of something can be patented. It doesn't have to just be how it works. It can also be a design could be patented. So that's why there's different types of patents. There's utility patents, which is that function based. There's most common. This invention does X, and this is how it does it. There's design patents, which is the aesthetic appearance of a product. So I can design patent um look of a MacBook is probably there's a design patent on that design style of a MacBook, just because again they're trying to protect it multiple. There's many different patents on a even a laptop, but that would be one. There's also plant patents, very rare. It's more like if you're in the agricultural business, you can actually get a patent on a plant, like when you are creating a new, whether genetic engineering, all that stuff, like you can create different types of plants. Or when back in the day when people were um, what's not crossbreeding, but doing different species of plants and creating a new plant, that can be a plant patent. Whether you do it the old-fashioned way of the drafting and mixing plants together, or you do it under with genetics. Um, Patents, the key thing is there's very patents that are a high hurdle. You just can't get a patent on anything. It has to be novel. So it's got to be new and not previously disclosed anywhere. So it's got to novelty is a big thing. It can't just be like, oh, I designed another toaster. Like, no, you're not gonna get a patent on that. Has to be non-obvious. So it can't be obvious to someone skilled in the field. So it's not non-obvious to the average person. It's non-obvious to somebody that has expertise in that area. So if I want to get a patent on a new invention and I'm an engineer, I'm going to look at it saying, well, I'm an engineer. That's kind of obvious to me that that would be the next step. So you can't get a patent on that. Like, so it's a very high bar. For utility patents, it has to be useful, has to have a practical use or function, which that's pretty standard. If it's a design patent, it just has to be ornamental, it's not useful. You have a 1-year deadline, so you must file within 1 year of the first public disclosure. So disclosing is a huge thing in patents. When somebody public, that's why people a lot of times are very scared to talk about their new inventions, because anytime they talk about it, they're concerned it might be a public disclosure, and that starts the clock ticking on them, and they may not be ready for that 1-year clock to start. So there are things you can put in place so you can still talk about your invention before you file the patent, but you just have to be aware of that. Ideally, you would never publicly disclose um, your invention. Like, don't go to a conference and talk about it and you don't have it protected before you go, because that starts that 1-year clock. And then once the patent is filed, it's a public document at that point, but the government has given you exclusive rights to it. So it is public. You have to reveal how the product worked. You have to reveal the invention. You can't keep it secret. So that's the other thing. People are like, oh, if I patent it, then I have to tell everybody how it works. I'm like, yeah, you do. But in exchange for that, you get exclusive rights to use it. You've got to disclose how it works. You can't just say it's magic behind the scenes, and because then how would anybody else know if they were infringing or not, or because they wouldn't even know how yours worked. It's a first to file, so rights go to whoever files first, not who invented first. So the guy in the basement working on stuff for 10 years, and somebody else comes out with a patented product in that time, and he doesn't. He's going to say, oh, it was my idea. Doesn't matter. It's first to file, not first to invent. Patent protection, you get 20 years from the filing date. So it's more limited than the other types of intellectual property. Design as utility and plant patents. Design patents is 15 years from the date it was granted, or filing date. Well, actually, filing and then granted. There are maintenance fees required of 3.5, 7.5, 5, and 11.5 years to keep those utility patents alive. So you still got to pay money during that 20. You don't get 20 years and never pay again. You got to continue to file these fees. Otherwise, it's considered abandoned. And if you don't file these maintenance fees, essentially. But the maintenance fees, the biggest expense is that initial filing versus the maintenance fees. And then no renewals. Like once that end 20 years or 15 years is up, your patent's up. It's open at that point. It becomes public domain. It ends permanently. Now you can file additional patents on like improvements, but you have to file on the improvement. You can't protect the original idea. You can only file the patent on a new novel, all those same requirements, on say an improvement to the product, but your original and your patent would only be applicable to that improvement, not on the original product. So just patenting's when it's a significant innovation, a competition, a competitive advantage. You might have licensing potential, so you want to get those things, the patent in place, because that's going to make your product more valuable to license. So those are just some things to think about. Um, patent filing is country by country. There's no, I file in the US, I get it everywhere in the world. Nope. You got to file in every single country that you want to patent in. That's where patents can really get expensive when you want to start selling into other countries and you have to start patenting filing for patent protection in those other countries. Cost in the US, it's going to be around 20,000. I mean, you can file a provisional patent that gives you like a year. That's where and for around maybe 2 to 3,000. That's where that kind of 5,000, that's at lower end. But when you factor the whole patent process and the legal fees because you need a lawyer for patenting, then that's going to run you about probably a good 20,000 in the US. You can file international. You think that was expensive? International can be super expensive. And you have to start filing in multiple countries. You can easily go 100, 150,000 on because of depending how many countries you file and which countries you file in. It does give you exclusive rights to that invention, which is great. And the idea is that it protects that inventor. So you can have time so you have that 20-year period to make money, recoup your investment. You kind of have that exclusive rights in the market to that. Or you can, again, license it to other companies. You can license that patent. You still own the rights, but you're licensing the right for another company to make and use that patent in their product. It's a very complex process. You have to hire a patent lawyer. There's just no if, ands, and buts about it. And you need not just a regular lawyer, you need a patent lawyer, somebody that understands patent law, because uh, you want them to write the patent as broad as possible, yet you still have to be narrow enough to get it approved. You can't be too broad. So and the patent lawyers usually have expertise, like they'll have engineering degrees or they'll have life science degrees. They have they're just not a lawyer. They actually have additional education in those areas where patents are filed, whether it's plants or life sciences or engineering and physical products. So they're going to have they're going to be worth their weight in gold. You want a good patent lawyer. Let's move on to trade secrets, unless anyone has patents, but I figure probably not too many people do patents. I dealt with patents since I was in manufacturing for 20 years. I did all kind of patent stuff, but most people aren't doing those. Trade secrets. So I've also dealt with trade secrets. So trade secret rights go to whoever can prove they invented or created the IP first, whatever that trade secret is. You have to prove that you created it or invented it first. Can be a little fuzzy because the whole point of a trade secret is not telling anybody about it. So you have to really document on the backside when this was invented so you can protect that trade secret. Trade secrets, there's a lot of things that can be considered trade secrets. Very few things actually rise to the level of a trade secret. So I'm going to talk about there's confidential information, and then there's the next level up as a trade secret. Trade secret is protected by intellectual property law. Just confidential information is not protected by IP law, but there are things you can do to protect confidential information, even if it doesn't rise to the level of a trade secret. So that can be consumer lists, it could be your customer lists, formulas. That's a big thing. The companies I worked at, our trade secrets were actually chemical compositions for that made up a product. And so that chemical formula or recipe was very much a trade secret. You can have other things like strategies, marketing plans, pricing. Um, Again, those can be confidential information versus trade secret, but they could also rise to a trade secret. It just depends on how you as a company view it and then the protections you put in place around it. Your software source code could be a trade secret. That could be one. Like that's why in those algorithms, all those AI models, Those are all trade secrets. They are very much protecting that algorithm on the back end, and they have put serious things in place to make sure that nobody knows how that algorithm works. And that's why they're protected, because they're saying it's a trade secret. It's why when people try to force them to say, well, what's your algorithm doing? They're like, it's a trade secret. I'm not telling you. Because if I patent it, I have to tell you what it is. If I copyright it, I have to tell you what the code is. So that's why those things are under trade secrets. That's kind of the biggest thing I think I see today mostly is or big pharma companies, their drug profiles, the chemical composition will be a trade secret. So they don't have to they do have to disclose to the FDA, but that's still that's different, and that's a protected document on how the drug works, but it's that's also they will consider them trade secrets as well. You can have employee training, business strategies, pricing information, and then sometimes employee knowledge and expertise. Those, depending on what they are, those could love right to trade secret. They might just be confidential information. Key thing about trade secret as it must have some kind of economic value. So a chemical composition has economic value to the company. It can't just be, oh, I want to keep this thing secret, not tell anybody, and there's no value. Most things would have a value to a company, but just kind of be thinking through that. It needs to have significant value to the company. It has to be secret. So the company has to take very specific steps to make sure that they keep that trade secret a secret. Even internally, there's very specific internal protections are put in place. You can't just have it posted on the internet that everyone in the company can see the formula. Nope, that is not a trade secret anymore, because you've not protect only if you limit the access, if you only certain people can see it, or only people that's critical to the job only see parts of it. Like, you have to really protect that information um, within reason. Like, you can't have it locked in a special vault and, secured away in a site, in Siberia, like that wouldn't be reasonable, but reasonable steps to protect that information and maintain the secrecy of it. Not just that you're protecting it from outside, but keeping it secret inside the company as well. There's no registration, no formal process. Again, it's a first to invent. The rights go to whoever they can prove they invented it first, regardless of when they actually use it commercially. So if I created a new formula and I don't put it in any product, I could still maintain that formula as a trade secret for 20 years if I wanted to, even if I don't use it commercially. It's potentially indefinite as long as you keep that information secret and as long as it stays valuable. Then it potentially a trade secret. The famous one that people always talk about is the Coca-Cola formula. That's a trade secret. That's been around for 100 and whatever many years. And Coke has kept that formula a secret, a trade secret. Um, and you'd have to have it like immediate loss. If the Coca-Cola formula became public, that would be an immediate hit to their company. That would be it's the economic value of that formula is high. So that's why they need to keep it as a trade secret. Again, for most businesses, probably not going to apply, but it's when that formula or process or uh, thing is so critical to your business that it's like essentially, if we don't have this, we would be in it would be a huge blow. It would be detrimental, incredibly detrimental to our business. You can put things in place like NDAs with employees, you sequester information. You can have physical security, like restricted access to things. So those are things you have to show that took reasonable steps, and that's reasonable is what the court's going to interpret as reasonable to keep that secret a secret even inside your own company, let alone outside. Now, a lot of things can be confidential information. They may not rise to the trade secret. So this is what I think most businesses think about. Like if you have, I'm thinking like your pricing list, your customer list with like your customer identifiable information, supplier lists, your strategy, your business strategy. Those can all be confidential documents, not confidential information, not a trade secret. Um, so you want to make sure that those things are protected. And so if you are sharing it with somebody, make sure there's an NDA in place. Like maybe it's a contractor that needs access to your customer database. Well, get an NDA in place with that contractor to make sure that they know they cannot disclose this customer information because it is confidential information. And train your employees on confidentiality. Key thing is just clearly mark documents as confidential. Like if you have, like we would do our 3 to 5 year strategy plans, and we just always put just, it's a PowerPoint slide, just put confidential on the document. So any file that goes out, it's clearly marked as a confidential information. Again, you can't always stop people sharing things, but it serves notice and can give you some legal protection that you considering this at least confidential, even if it's not a trade secret. And then making sure you securely dispose confidential documents. Don't, if you mark it confidential, don't throw that PowerPoint deck in the regular trash, shred it or put it into like a service that does that. So you have to make sure that you're maintaining that confidentiality throughout creation and disposal. So we're just talk, sorry, would an NDA agreement fall under the term trick? No. So an NDA is just a legal document. You could get an NDA if if you need to disclose. So say you needed to disclose a trade secret to a vendor or somebody outside your company. So NDAs aren't within employees. Employees are employee contracts. In your employee contract, you should have a confidentiality clause. Like that should be baked into everything. You can't tell people about stuff, all that stuff. But if you needed to do, like we do NDAs all the time where we need to talk to suppliers or vendors about any confidential information, whether it's trade secret or just regular things about our business, you want to get an NDA in place. That means that they can't share anything they learn about the company externally outside of the relationship or what they need to with the company. So it's NDA is just a legal document to protect any confidential information, trade secret or your customer list or your pricing document or your 5 year strategy that you're showing to a vendor. So, or any discussion about anything proprietary like research being conducted. If it's not public knowledge and you want to make sure that, hey, for working on something that's going to kind of be information that's not publicly available, get an NDA in place. Hopefully that helped, Vernon. We're going to talk a little bit about IP strategy. If not, just kind of throw in the chat again. So we talk about all these different assets, all these other things. What I file, when I file, where the things are, what are my protections, that kind of stuff. So kind of let's take some clear steps that you can start because that could be a little overwhelming. So let's kind of start with like building out an IP strategy because even if you're small, you still there are assets in your business that are IP assets, whether you can think of them that way or not, but you need to kind of figure out like what do I have? And then what are the protections I need to make sure that are in place? So we're going to kind of talk about some basic steps. First, I would say we're going to talk about conducting an IP audit so we can identify those key assets. I would prioritize protection. You may not be able to do everything all at once, but how do I prioritize? And then what are some protection measures? And then monitoring and enforcing. So kind of covering that. First, conduct an IP audit. Just figure out what you have. You don't even know what you can protect if you don't even know what you have. What are the creative works? What are the things that make your business unique? What confidential information do you have that gives you advantages? Like, and the next slide, I've got like kind of some examples of IP assets that you may not think about, but just kind of think through they're like business assets, what your business name, any DBAs are doing business as, because some companies have a business name and they may have a DBA. Your logos, your taglines, the slogans used in marketing. Are you known? I've known people that will like have a catchphrase that they always use. Like, well, they need to think about that's an IP asset that if that's kind of identifying or synonymous with their business, then you need to protect that as a trademark or whatever, whatever form it is, but think through that. Your products and surface names. So we would trademark every single product name. If I came out with a new line of products, we're trademarking that name. Or service, if you have a service, um, like say you do packages and you offer three different types of like your a hair salon and you offer these kind of packages and you name these packages. Those things are could be service names or like it's the deluxe package and then whatever, but just kind of think it through, but more not generic, but if you kind of have these names for different types of products, whether it's a service product or a physical product, think about registering those names. Website domain names, again, we talked about them not being um, intellectual property, but they're still, and social media handles, there's still assets in your business, and you still need to make sure to kind of protect them in different ways, even though they don't fall under IP law, but you still want to make sure that those things like their domain name is registered with ICANN and that your social media handles that you've registered those with all the different platforms, even if it's not IP, with the federal government. Any distinctive packaging or trade dress, you want to make sure to have look at that. Like you have a very distinctive, like I said, the DeWalt yellow was a huge thing for trade dress out of the Coca-Cola, bottle shape. Um, any color schemes, design elements, things that you kind of consistently use in your branding, you may not be able to, they can all be kind of protected um, if you're kind of consistently using them, even if they don't, again, don't rise to the level of a true trademark or copyright. You still need to look at those and say, hey, are there things that really kind of identify my business that a symbol that I always use that kind of is synonymous with my business, things like that, design elements that are, you have to kind of start thinking about, are you tying them so tightly to your business that you need to protect those assets? If a competitor started using them, would it hurt your business, basically? There's also, you need to look at your creative and marketing content. So your website content, usually you have that little C at the bottom of any website page. It's your blog posts, your articles. There's your marketing materials should always have a copyright on the back, in your tagline, copyright by blah 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 business. Any photography or graphics use your business, whether you took them or paid for them, you need to make sure that that you have the protections in place. If you're using like a stock photo from a service, you don't own the rights to that. That you're purchasing the rights to use that stock photo. But again, if you actually hire a photographer to go out, you want the rights to those images because it's a work for hire. That photographer took them for you. So part of that contract is making sure that you have those copyrights assigned to you from that photographer. Any videos, presentations, training materials, software, mobile apps, and then any written procedures, manuals, guides, just making sure that you go through and kind of look at everything you have, as well as, making sure that either a copyright or trademark is, if it's marked, if it's filed, like you just kind of looking at all those assets. Then you want to kind of prioritize the protection. So maybe you have a bunch of things and you've never filed for any of them and you haven't marked anything. You're like, what? So just kind of thinking through, like, hey, of all these assets, what are the most critical? All right, let's start working on getting those protections in place. Um, what would be the most, what would hurt me the most if some competitor copied it? So that's kind of a way to kind of prioritize. If you can't do everything, like start working on the list of, okay, let's get these protections in place. And then work on this group of protections. Or, some things might be simply of, let's make sure that little copyright symbol is on every single thing that we do. Like, let's just start working on that. Because some things you can do internally, some things might actually have to be like federal registration, but kind of start laying out a plan for those things, what's protected, when it's done, and kind of checking it off. And then again, following the registrations. Um, if you need to have NDAs in place, like get an attorney to create like a basic NDA document for your business that you can use with vendors and suppliers. Training employees on any kind of like, hey, this is confidential information. Make sure you mark this price list or this customer list or whatever it is as confidential. Um, establishing those kind of protocols for when you talk to external partners or internally, then you can kind of consistently kind of do that and explain that the importance of that again. And most businesses understand that. Other people you deal with should understand um, what confidentiality means and how to protect that and then getting with an attorney to file the appropriate registrations for your different marks. And then you really have to watch and enforce. I will say, um, it's going to be hard. You're not going to go out and like hire somebody to scroll, the internet and find every infringer. That's not going to happen. But if something comes to your attention, if you filed the trademark, or I filed the registration, filed it, even if you haven't, and it comes to your attention that somebody could be infringing on your copyright or trademark or patent, then you must take action. Here's the issue is that if you know about it and you like, oh, well, they don't do anything, it's fine. What that does is sets a precedent that you aren't serious about protecting your rights. So if somebody later comes in and infringes, and it's a much bigger deal, it's a competitor, and it's not just like oh, this is like an intentional infringing. They can, when you go to court and say, hey, they're infringing, that competitor can say, well, look, so and so infringed before and you didn't do anything about it. So you obviously didn't care then. So you're just so your position becomes weaker because you didn't like I said, if you know about it, there's things out there you'll never know about. And unfortunately that's happened. But if you're aware of it and they can prove that you knew about it and did nothing, and what I'm saying, even a lot of times infringement, you can just go to a lawyer and say, I need you to write a cease and desist letter to this company over here that's infringing. And usually people are like, oh, I'm sorry, I didn't realize I was infringing, and they'll back off. I mean, usually it's like a cease and desist letter. Very rarely does it go to like a full-blown lawsuit. But again, having it registered with the federal government helps you on those lawsuits as well as any attorney fees. Um, but that's what I'm saying, that so you really do have to, if you want to have these rights and you're serious about protecting them, you have to take steps to protect them when you're aware of infringement actions. And then you get to maintain your registrations and your renewals, just making sure you pay when those fees, when those come due for, renewing anything. You don't want to do all the work of filing for something and then let it lapse on the back end because you didn't pay a fee when it needed to at the 5-year mark. So two resources. Oh, getting about time. The USPTO is the US Patent and Trademark Office. They have a great, or well, both do, and the US Copyright Office, great resources. They have trainings and webinars and documents and helpful frequently asked questions. I mean, they have a lot of resources out there for small businesses to at least figure out. I mean, again, things will take the more things that you can have prepared before you go to attorney makes it easier, quicker, and cheaper for that attorney if you have kind of all your ducks in a row before you go to file. Like if you have, okay, I know you need a proof of use picture. I have that done. Like you already know, because these can be resources about what kind of things you need. So you can always have them prepared. So when you go to a lawyer to get it filed, to do the actual filing, it'll be much quicker and easier for them. All right, and that is the end of the presentation. So is there more? Yeah, NDA is a tool. Thanks, Vernon. Okay. Is there any other questions you want to drop in or come off mute and ask? That was a lot of information, but you'll get the recording.
Yeah, thank you, Sandy. The recording is going to be of great value to be able to review and kind of go, oh yeah, I kind of remember her saying
hmm
that.
Yeah. And I will say my slides, I think Michelle, you'll send out a PDF of the slides afterwards too. Um,
Yes, ma'am.
and they're text heavy because I figure that you'll be something you're like, well, what did she say about that? And you can go back and refer to the slide if you don't want to watch the video. I hate slides that are just like, it's a slide and one word on it. And you're like, well, what does that mean? That's not helpful to me afterwards. So I do put a lot of text on them so you can have them as references later.
So any questions or comments, please unmute or enter into chat.
All right.
Sandy, we really appreciate your expertise in this area. And I know for SCORE clients and customers, these are questions that always come up. So it's a great start. And if nothing else,
Well, I
um,
saw one more from Christina just popped in. What steps should you take with an NDA for a proposal with for a company? So when you're doing a proposal in the beginning, there's probably not going to be an NDA in place. You're just submitting usually there's nothing confidential in the proposal. You're saying, here's the scope of work, here's the timeline, here's the budget, blah, blah, blah. When you actually engage in the work with the company, there should be a contract at that point because it sets out how you're going to get paid, when you're going to get paid. It formalizes that scope of work and everybody agrees to it, timeline, all that kind of stuff. And in that, it may not be an NDA, but there will usually be a confidentiality clause in that contract, even if it's an NDA is usually a separate document. Like if you need to have discussions about confidential information before you've entered into like a formal agreement or contract. But that contract itself should have from the company, or you can put it into, but the company usually will put in a confidentiality clause. It's essentially the same thing as kind of an NDA where you're saying all the information that you learn about the company during this contract of work is confidential. And that's where they assign the rights of any product that you do goes back to the company. That kind of stuff will be in the contract. Oh, for proposal for improvement to gaming. It shouldn't matter industry. It should all be your scope work or proposal would not usually have unless you need confidential information from the company to create the proposal, then you would want an NDA in place, or the company will want the NDA. It's like if you need to get for gaming, like if you need to get access to their code or something, I'm trying to think of, so you could see like, oh, well, I can build on this. I know what you already have, so then I can quote out how many hours or whatever it's going to take me to improve on this gaming platform. Um, you might have to have an NDA, but usually the company is probably going to be the one driver of the NDA. If they don't ask for it, that's on them. I mean, it's whoever's sharing the confidential information. In a work for hire contractor situation, more likely the company is sharing the confidential information. If for some reason you are sharing confidential information, then you would need to have an NDA as well. I mean, like you would say, hey, company, I need you to sign an NDA to protect if some reason you were sharing confidential, most likely it would be company information. Um, most NDAs most NDAs are bilateral, meaning you want the NDA to protect both parties. So if it would protect the company and it would protect you as the contractor in the NDA. Some NDAs can be unilateral, meaning like the like only one party is going to disclose information, like the company. So it may be a unilateral NDA where only their information is being protected. So you just have to be aware not to share anything confidential. But most NDAs are bilateral, but you'd have to look at the NDA language and it'll say, it's protecting both parties or it's just protecting the company information. I don't know if that helps or not, or if that answers your question. Oh, okay. I would say before you're signing any contract with a company, you always want to, I say make sure a lawyer just kind of looks at it. And it shouldn't be too much for them to kind of check through just to make sure, because companies are going to be looking out for their best interest. Most things are pretty standard. In NDA language, usually it's pretty standard. I've come across some that are just like, that's a little odd. Or they'll want all rights to something and like, no, you're not really, like so you just kind of because they're going to write it where they get everything, or they're only like, or it might be unilateral and you're not realizing that. And like, no, I've got some information I'm sharing that you need to keep confidential, company. You just want to make, so that kind of stuff. But most companies aren't trying to trick you. They NDA and an attorney can look at an NDA language pretty quickly and not be too much of, they can kind of skim through and what they're going to do is just tell you like, hey, they're not going to tell you yes or no, you should sign or not, but they're going to say, hey, these are some flags or these are some things I see. Or like, no, this is pretty standard language. There's nothing in here that's surprising. You're like, okay, good. Just need to check it. So, all right. Well, if that's all, then we're about done on time. Pretty close. Give you back a few more hours in your day or 1 hour in your day.
Good job, Sandy. Thanks so much.
Thank you. And thank you everyone for, being here on a Saturday morning to talk about intellectual property. Riveting topic, I know, but it's pretty kind of necessary and critical to your business to make sure you've got protections in place. So thanks for your time.
Absolutely. Thanks, everyone. We'll see you on the next webinar. Take care.